My name is Kristen Anderson, and I am a senior criminal defense social worker at the Bronx Defenders. The Bronx Defenders is a public defender nonprofit that is radically transforming how low-income people in the Bronx are represented in the legal system, and in doing so is transforming the system itself. We have pioneered a groundbreaking, nationally recognized model of representation called holistic defense that achieves better outcomes for our clients. Each year, we defend more than 20,000 low-income Bronx residents in criminal, civil, child welfare, and immigration cases. As a criminal defense social worker, one of my primary responsibilities is advocating for and identifying alternatives to incarceration that both meet my clients' identified needs and resolve their criminal cases favorably. As such, I have an intimate knowledge of the landscape of ATI resources in New York City and areas in which expansion and improvement is needed to best serve our clients' needs. I first want to thank members of the Committee on Codes and the members of the Committee on Corrections for taking the time to listen to this testimony today, and for dedicating time and energy to think creatively about how to best serve New Yorkers after contact with the criminal legal system through alternatives to incarceration and pretrial services. The passing of bail reform was a monumental step forward in reducing our jail population and curbing the tide of mass incarceration, and requires us to assess available pretrial services and alternatives to incarceration with the goal of making significant improvements and expansions to meet demands. We must balance this new need with a firm commitment to the presumption of innocence and not to widening the net of people under state supervision. We have identified ways in which the structure of mandated treatment often fails our clients and recommend the following. First, ATIs and pretrial services will yield better outcomes if determined by client needs as opposed to the nature and severity of their charges. The goals of a punitively criminal legal system are in conflict with the goals of a truly client-centered treatment program which produces the best outcomes. The phrase, "the punishment fits the crime," does not equate to "the treatment fits the crime," because a person's need for treatment often has nothing to do with the facts of their legal case or the severity of their charges. Second, the looming threat of jail does not motivate people and instead impedes their progress. Pretrial alternatives must not hold jail sanctions over people's heads in the event that they do not complete services to the satisfaction of the court, but rather the successful completion of services must be rewarded with positive consideration in the resolution of their cases. Third, a strengths-based view of participants is critical to success. Shifting the way system players, service providers, prosecutors, judges, and clinical court staff view and think about our clients would greatly improve our ability to address the underlying factors that led to their criminal justice contact, meeting their psychosocial needs, and pursuing their legal goals. We have also identified ways in which increased funding could close significant gaps in available services. First, individuals with co-occurring mental health and substance abuse needs often fall through the cracks. Existing outpatient and residential substance abuse programs often do not have the appropriately credentialed psychiatrists and clinicians on staff to treat co-occurring mental health diagnoses, and tell us that our clients require a higher level of care that simply does not exist. Even the treatment providers that market themselves as serving people with co-occurring disorders discriminate based on certain presentations of mental health symptoms, such as suicidal ideation, hallucinations, and delusions. This is a glaring treatment gap, given how common co-occurring mental health and substance use disorders are. This gap in services results in the chronically mentally ill and chemically addicted population falling into a cycle of homelessness and incarceration simply because there are no services equipped to meet their level of need. Second, language access limitations and insurance ineligibility leave immigrant New Yorkers at a constant disadvantage. There are very few specialized programs such as sex offender treatment, domestic violence services, and vocational and educational programming offered in Spanish. Furthermore, mental health and substance abuse treatment services are not only limited by language access, but also by insurance eligibility. While there are some providers in the city that are funded to provide these types of treatment services at no cost, these options are few in number and often far from where clients live. The obstacles are even greater for clients who seek inpatient or residential treatment services as their necessary and desired level of care. While state-funded addictions treatment centers are an available resource for 28-day inpatient rehabilitation, regardless of insurance status, there are no affordable options for long-term residential treatment for the uninsured. Third, individuals with the highest levels of need are often barred based on the severity of the charges against them. As it stands currently, people charged with most violent felonies, especially felonies that are sexual in nature as well as arson, are ineligible to enroll in most programs. This gap in eligibility criteria creates many missed opportunities to address real issues of violence in impacted communities, as well as missed opportunities to truly address complex and interpersonal trauma for some of the most affected individuals. We further propose that investment in creative, community-based, client-centered programming is key to successful outcomes. First, we need creative programming options for everyone, but it currently only exists for special populations. Unemployment or underemployment is a common factor identified by our clients, regardless of age, in creating instability in their lives and driving their involvement in the criminal legal system. Currently, certain groups, most notably young people, are able to take advantage of a plethora of therapeutic, educational, and vocational services tailored to this special population. Unfortunately, when they exist, vocational programs for adults are often limited to high school equivalency classes and construction skills. We must think expansively about how to create creative and innovative programming for adults. Second, impacted communities and individuals know what they need. To achieve transformative change, any and all services must be personally tailored to meet the needs and goals of the individual. Too often, our clients experience a one-size-fits-all approach to treatment and services. This happens in the context of determining the appropriate ATI, for example, when a certain charge is met with a specific program without regard for the particularities of that person's experience and circumstances. Third, success is more likely when program requirements are manageable and goals are achievable. Our clients are often juggling many responsibilities, and we must take direction from them to avoid imposing barriers to their success. Rigid requirements of treatment programs often leave clients facing the impossible choice of maintaining work or complying with their mandate. Too often, clients become inundated with programming to a point that it becomes not only unmanageable for them, but also ineffective in its intended purpose. We must trust our clients to determine what they need and also what is possible for them at this juncture in their lives. Last, smaller grassroots settings lead to stronger relationships and stronger communities. Many of our clients have been very successful working with larger scale programs that serve people from all over the city and sometimes even the state, who are open to participants of all ages, genders, and backgrounds. These programs are an incredible resource, and we support their continued funding. We also see, however, that many of our clients benefit from a different program model. We encourage the Assembly to consider investing in small, community-based programs with the understanding that every community is different and the faith that the community knows what its members need to succeed. We conclude by recognizing that we are in a critical moment to expand and improve upon existing ATIs and pretrial services to ensure that they meet the needs of individuals with criminal legal system involvement. addressing the flaws in the structure of mandated treatment and programming, the current gaps in existing services, and implementing changes that truly center the needs of impacted groups are crucial next steps to realizing the goals of bail reform legislation. These changes represent a radical paradigm shift away from punishment and incapacitation and towards transformation and rehabilitation.